So for our first panel of the afternoon, we have a discussion on the due regard and responsible behavior, how to operate with due regard for others. To moderate this panel, we are delighted to have Colonel Ted Richard. Colonel Richard is the Staff Judge Advocate for Space Operations Command at Peterson Space Force Base, Colorado. The Field Command of the United States Space Force, Space Operations Command generates, presents, and sustains mission-ready space forces for U.S. Space Command and other joint commands. Over to you, Colonel Richard.
Thank you very much. I'm going to stand up at the outset and introduce my panelists because sitting sideways is it's a little too awkward when I'm trying to start out and talk. So our first panelist today is Major General David Miller. He is the Director of Operations, Training, and Force Development. What in the military, the acronym we use for that is the J37. For the headquarters, United States Space Command. He's got offices at Schriever. He's also got an office over at Peterson with us. And as the J37, he is responsible for executing the full spectrum space operations, maintaining credible space deterrence capabilities, providing analytical planning support, and the combatant command's participation in joint exercises, as well as the education, training, and assessments of assigned and attached space forces. So that he's got a lot of responsibilities there. Our second panelist is Ms. Robin Dickey, who's a policy analyst for Aerospace Corporation. And Ms. Dickey focuses on space policy and strategy issues related to national security, geopolitics, and international relations. Next on our panel, we have Mr. David Edmondson. He is the policy head, space security and advanced threats, and leads work for the British Foreign, Commonwealth, and Development Office on Space Security Policy. And finally, we have Ms. Katie Festel, who's an assistant policy researcher at RAND and a PhD candidate at Pardee and RAND Graduate School. So please welcome our panelists. And so my plan for how I wanted to go about this panel is to start out by giving you a little bit of a TED Talk as a scene setter, as a backgrounder for what we're going to talk about, knowing that some people in here are new to space law and some of the space law issues. And then I'll ask a question to each of our panelists, and then we'll turn it over to our audience for further questions. So I am assigned to the U.S. Space Force. The Department of the Air Force has both the U.S. Air Force and the U.S. Space Force in it. So right now I am a Space Force asset, even though I'm in the U.S. Air Force. It's a similar construction to the way the Navy and the Marine Corps have theirs, both in the Department of the Navy. But we'll start out with the scene setter. So for due regard in outer space, the due regard in outer space is a term, for those of you who don't know, from the 1967 Outer Space Treaty. It's part of Article 9. Ms. Talk this morning, I think, talked a little bit about that, talked about Article 9 of the Outer Space Treaty. Let me just read you the term in the treaty, which says, in the exploration and use of outer space, state parties to this treaty shall be guided by the principles of cooperation and mutual assistance and shall conduct all their activities in outer space with due regard to the corresponding interests of other state parties to the treaty. Due regard, however, is never defined in the Outer Space Treaty. It is a term that's commonly found in other treaties, like the UN Convention on the Law of the Sea or the Chicago Civil Aviation Convention. But interestingly enough, neither one of the other treaties defines due regard either. So it's a term that people recognize, that people may be familiar with, but it isn't defined within the treaties. So why is it important, and why is it important today? Well, let's go over some issues that have come up historically with the due regard issue. And I think the first one that I hone in on is in 1996, two European space assets collided with each other. It was a French series military reconnaissance satellite and a European Space Agency Ariane rocket component. They collided, and a lot of debris was caused. And then we fast forward to 2007 when China did their ASAT test. And Ms. Tak mentioned the ASAT test again this morning. It also created a significant amount of debris and resulted in a lot of international condemnation. In fact, it was pretty much uniformly condemned internationally, but interestingly, none of the condemnation cited due regard, or the Outer Space Treaty. No one called it out as a breach or a violation of international law. The condemnations were more just on lack of responsibility. 2009, two Russian space entities collided, a commercial Iridium-33 and a derelict Cosmos satellite collided, created more debris, excuse me. And then in December of 2020, the UN General Assembly, I think with a lot of support from Mr. Edmondson, I think you had a lot of work on that. The UN General Assembly approved a resolution expressing a desire for nations to reach a common understanding on how best to reduce these threats and concerns in space. Following that, in July of 2021, we had the Tenets of Responsible Behavior that Ms. Tock mentioned this morning in her presentation. And so there's 5 tenets, but I think 3 of them are very relevant to this particular panel. So operating in, from, to, and through space with due regard to others in a professional manner is one of those tenets of responsible behavior. Maintaining safe separation and a safe trajectory, and then communicating and making notifications to enhance the safety and stability of the space domain. So that's what we're going to try to flush out in this panel, the background and how we go forward, move forward collectively with some of these tenets of responsible behavior. In November of last year, Russia had their big ASAT test, which caused a significant amount of debris. 1,500, that's 1,500 pieces of trackable orbital debris, and likely hundreds of thousands of smaller debris in orbit. In response to that, General Dickinson, the commander of US Space Command, issued a statement that said Russia has demonstrated a deliberate disregard for the security, safety, stability, and long-term sustainability of space domain for all nations. And then finally, on an interesting kind of side note to all of this, in December of 2021, China came forward to the UN and filed a complaint that was picked up widely in the media that Starlink satellites launched by SpaceX, the United States of America, had 2 close encounters with the Chinese space station. And so for safety reasons, their station had implemented preventative collision avoidance in July and October of 2021. When they filed their declaration with the United Nations, China specifically cited Articles 5 and 6 of the Outer Space Treaty, which relate to state responsibility and notification procedures, but they didn't explicitly say any violations of a treaty occurred, and they just reminded people about obligations under the Outer Space Treaty generally. In January, in response to the Chinese statement, the US filed a response with the United Nations that said that those activities did not meet the thresholds of any established emergency collision criteria. Therefore, emergency notifications were not warranted in either case. So as we go to the panel, and I'm going to turn it over to the panelists to each make an opening remark before we go to questions, but the fundamental things we're looking at here is due regard as a treaty obligation, albeit undefined. And so states, at least from the examples that I've cited, appear to be reluctant to declare specific activities to be in violation of the Outer Space Treaty. So what's next? And given this lack of specificity, what should due regard look like in outer space, and how else can we promote safety, security, and sustainability in outer space? So with that, I'm going to turn it over to General Miller for his initial thoughts on this topic. General Miller, the floor is yours.
Laura Calise. I was deployed with Laura Calise. Let's have a round of applause for Laura Calise, my battle buddy from Iraq. You guys didn't tell me you did a plant in here. Hey, good morning. I guess it's good afternoon. Thanks for the opportunity to be here today. This is an important topic. I wanted to give you a few remarks about the perspective at which I'll be giving my comments today. I'm mostly interested in hearing from you. My perspective is both as a Space Force officer whose statutory requirement is to ensure freedom of action in the space domain and protect U.S. space interests, and also as the Director of Operations Training and Force Development at U.S. Space Command, who takes the forces that Space Force gives us, in addition to the Army, the Navy, the Marine Corps, and so on. And yes, All of them provide forces to United States Space Command. And then we try to provide both the strategy, the operational planning, and the current operations synchronization to ensure that the services and capabilities that you rely on are available through all phases of conflict. Most importantly, I'd like to say on the topic of due regard is that this conference couldn't have come at a better time. There are a number of things that have happened in the last 2 years, not the least of which is the stand-up of both U.S. Space Command and U.S. Space Force that have made really digging into these concepts and discussion points most important. And they have also led us to develop new relationships. And you see on this panel, there's only one of us wearing a uniform. Perhaps like no other service, I think Space Force is going to be more cooperative and have more of a dependence on varied schools of thoughts and diverse approaches to solving problems than perhaps any other military service in the past. And that is because perhaps unlike some of the other military services, we have partners with us on a day-to-day basis who we are leveraging, whether they're commercial, international alliances, or other governments that we're working with, whether they want to be stated or not stated, that we are trying to do our best to ensure that that statutory requirement for freedom of operation is maintained. The principles that we're talking about here, whether it's due regard or some of the topics I want to talk about on responsible behavior and identifying what that looks like, are going to be keys to ensuring that, number one, we prevent miscalculation. Number two, that we hopefully avoid any escalation, either horizontally or laterally. And number three, that we can assure both our allies and potential adversaries of U.S. actions and interests. I think in the space domain, that is particularly challenging. While you may take for granted that in the air domain or even in the maritime domain, because of space services we provide, you have general, almost ubiquitous awareness over almost every populated area on the globe. That is not the level of awareness that we have in space. We rely on episodic observations of space capabilities, debris, or otherwise. And that frankly comes at a frequency and a periodicity that's sometimes not what I want as the director of operations. So the necessity for understanding of both what we expect from each other, the timeliness at which we'll be able to engage, and some of the parameters at which that engagement will look like is going to be even more important. And that's why I think it's important that U.S. Space Command is here today. Thanks for your time. I look forward to the discussion.
Ms. Dickey?
Thank you. Really honored to be here at this panel today to talk on this topic. I certainly agree with General Miller that this is a really important topic and a really important time to be discussing it. And the lens that I bring to the discussion on due regard is really looking at norms of responsible behavior for space. And since the question of definitions is on the table, I might as well put forward my definition. So I tend to think of norms in terms of general agreement on what kinds of behaviors are acceptable or unacceptable among a certain community. So for example, the community of space actors. And an important angle on this lens is that it really sits at the intersection of law, policy, regulations, standards, voluntary actions. The question really is, how do we get the international space community to have this level of general agreement on what's acceptable and what's not acceptable to do in space, with due regard being a significant part of that. And a challenge that really comes to the forefront with norms is that norms have excellent benefits. General Miller listed a couple of them, but every norm also comes with a cost of some kind in terms of some limitation on freedom of action, just by judgment that something is acceptable and something is not. That means that when you're trying to build international commitment to norms, you have to be thinking about how each actor is going to weigh the cost-benefit analysis when they're deciding whether to support it. And so in my research, I've written a paper called Building Normentum, because I can't resist a good pun. And it's the idea of a 4-point decision framework that is, what are the different questions we have to ask ourselves when trying to lead the international development of norms? And so the first question is, how is an actor internally figuring out what they're going to propose, what they're going to support? So from a US perspective, that's how are you doing interagency coordination? Which agencies are leading? How are you drafting the language? That can be a big challenge with lots of different options for how to proceed. And then the next question is, who are you bringing this proposed norm to initially on the international stage? Do you start with your partners and allies, which can be a really great way to kind of build that initial momentum and consensus among a small group? But with that, you run the risk of a perception of exclusivity when you try to bring it to the broader international community. And the third question is, what are the mechanisms that you're using to establish commitment to norms? And I think this is a big one for the conversation today, because this is where you're weighing whether you're looking for legally binding treaties or other agreements. Are you looking for non-binding voluntary guidelines, such as General Assembly resolutions? Are you looking at principles that can be established directly through partnerships, bilateral or otherwise? So the Artemis Accords might fall under this example. Or are you just looking at unilateral swells of condemnation or support for certain behaviors, which is a really common way to establish norms, but runs the risk of lack of definition, lack of universal understanding, especially when you think of language and cultural barriers as being a big impact on international norms. And then finally, the last question is, where are your goalposts? What is the target that you're setting for how many countries, how many actors need to buy into a certain idea in order to consider it a norm? Because this varies greatly based off of the capabilities involved in what you're looking at. It might involve state actors, it might involve commercial entities, it might involve international, intergovernmental organizations. But it's important, if we're taking a strategic approach to looking at questions of norms of behavior and due regard, that you really think about where your end goal is so that you can take the steps and measure progress towards that goal. And so with that, I'll pass it off to Mr. Edmondson.
Thank you very much. With great apologies, I'm going to have to read off the laptop because I was writing these at Heathrow yesterday and I haven't had a chance to print out my remarks. But to start at the beginning, we do this work to avoid conflict and prevent an arms race in outer space. Responsible space behaviors is an approach to shape the operating environment and to constrain hostile state activity, whoever that may be. You'll note that I say responsible space behaviors rather than responsible behaviors in space. Sorry, Jeremy. For us, there's a big policy difference, but more on that later. We take a holistic view across domains and consider the effects on space systems and the role they play in wider national security. So space is an integral part of integrated deterrence. To prevent an arms race, it's as important to consider and protect the data, the information, and the signals, just as much as the satellites that provide them. So PAROS, preventing an arms race in outer space, that's the approach at the UN to managing space security, is from 1978. It established this agenda item and didn't mandate any particular outcome. That's where we and the Russians get into a big policy argument because they say it does and we say it didn't. But hey, it's not unusual to argue with the Russians at the moment. We can't limit an arms race or deliver space security without taking into account all of the elements of the space system. So we need to consider the role of new novel technologies as well as existing ones like missiles, and include non-kinetic threats. So it's useful to take an effects-based approach in many of the cases rather than limiting particular counter-space weapons. And as I say, the responsible space behaviors work is about managing and mitigating the national security aspects of space. So there are many drivers in orbit and on Earth. It's the development or deployment of counter-space systems that threaten the use of space systems. Better offensive weapons drive improved defensive capabilities. Threats drive defensive systems and overmatching offensive counter-space ones. So I think about all the ways we can avoid miscalculation, escalation, as was mentioned earlier, conflict. We want to consider behaviors, the actions, activities, and omissions, alongside intent, the thoughts, and combined, these deliver threats or the perception of a threat. We talk about responsible behaviors and how we would use agreed behaviors in cases of feeling threatened. The outcome of the responsible space behaviors approach is supposed to provide a starting point for conversations between states. So to enable those conversations, we should consider some questions. Do we have a common understanding of how our actions impact our perceptions? Do we have a shared language? Do we understand how one generally acceptable behavior might be unacceptable at times of heightened tension? Some behaviors can't be defined, and maybe that's the point. I'll give you an example, and I'll use the definition of too close. As an operator, you want to avoid collisions. If the capability is a missile, then too close is your response time, launch to bang. If the capability is an electromagnetic pulse, then too close is the range of the pulse. So we can't always say 20 kilometers, and it's going to vary between orbits. What we as diplomats are interested in is the concept of too close and perceived threat. We'll need to think through how we present this. It's fluffy. It's a fluffy solution to a practical problem that most nations will assume can be solved by a rule. We want to enable those conversations as the resolution to the perception of threat. So in a similar vein, is jamming unacceptable outside of conflict? Does it matter what system you're jamming, navigation signals, or ballistic missile early warning data? I'll touch briefly on my role, the role of the UK. So in 2019, Russia was winning the narrative. They put no first placement, prevention of the placement of the weapons in space treaty, further practical measures on the table, and claimed we had no offer. So this current approach actually came from walking around the inner circle when we were doing Shriva. We learned from US efforts in the first committee in 2019, where states told us they don't want to be forced to choose between the US and Russia, and the EU code of conduct that failed because it was presented as a fait accompli. We were building the narrative through 2020, sharing thoughts with a wide range of states. We did lots of outreach, starting with the Wilton Park Conference in Singapore, to which we invited ASEAN states and China, plus other regionals. We worked with a group of friends, and then the pandemic hit and we went online. At the UN General Assembly that year, all of our outreach and lobbying bore fruit, and Resolution 7536 set up the UN Secretary General report. In 2021, we moved on to leading the debate. I say we, I mean, it's the UK whose name is on this thing, but it's a small group of states, including the United States, that work very hard to make sure we collectively deliver what we want to. The UN Secretary General report issued in July after states had fed in their views, and it's an excellent report. We lobbied and influenced globally and in New York, and we succeeded with a follow-on resolution 76231 that set up the UN Open-Ended Working Group. All states can meet and discuss over 2 sessions in each of 2022 and 2023. That's 4 in total, and not the 2 that the Russians use if you use Russian maths. The reference there, of course, is that they managed to persuade the group to delay the starting point from February to May, while they argued as to how many 2 + 2 is. The Open-Ended Working Group had the organizational meeting in February. The first session will be in May, and we will submit a working paper. That's how you get your views recorded. Quickly on the topic of the panel today, due regard, to act with due regard to the interest of other state parties. My thoughts come from a policy perspective. How can I use the legal advice I get to shape my adversary or shape hostile activity? There are challenges to call out activity using Article 9 of the OST. We simply haven't used it before. And as we mentioned earlier, for the Russian ASAT test in November, we called them irresponsible, we didn't use Article 9. I wonder if you could apply the principle of due regard to non-kinetic counter-space threats. With the aim of shaping hostile state activity, does due regard have utility in a behaviors-based approach? We've been working for over 3 years, bilaterally, multilaterally, in small groups and at the UN, to move the debate from the Russian-led treaty approach to a broader view of space security, to think how we can use existing and new mechanisms to shape the behavior of hostile states. So I encourage you to consider if, given the current lack of a clear understanding about what exactly it means in practice to act with due regard, to think if it is a useful legal concept to use on the policy problem of irresponsible space behaviors, especially the non-kinetic activity, such as jamming, spoofing, or other RF interference. How do we make this principle stick in the competition phase outside of armed conflict on things that most of the world can't see, when it will be a situation with 2 competing narratives? So thanks. And if we don't get a chance to discuss now, I'd welcome the chance to talk over coffee. Thank you.
Great. Thank you so much for having me here today. It's exciting to be able to talk about such an important topic with you all. So first, I want to look at what we can learn from other domains. So the law of the sea, UNCLOS, offered a similarly vague definition of due regard, But when you look at the International Tribunal for the Law of the Sea and the Permanent Court of Arbitration, they both looked at it as a balancing exercise, trying to balance the nature and importance of the rights of the parties involved and the scope of the impairment of those rights that may occur when these states engage in activities that create conflict. If you look at air, you can see that they have, there's this definition of due regard for aircraft and missiles and projectile firings, but there's also this condition when it's not practical or compatible with the mission to follow the ICAO flight procedures, that there is this other set of rules to follow if you're outside of that. But there still are rules, and those rules are to still maintain safety. So even if you're outside, you still have to follow something. But perhaps maybe climate change is a better domain to look at, as it presents a similar tragedy of the common situation where we have a shared resource system in which individual users acting independently according to their own self-interest behave contrary to the common goal of all users by depleting or spoiling that shared resource. While climate change doesn't have a due regard principle, they do have a no harm principle, that no state has the right to use or permit its territory in a manner that causes serious injury to the territory or another of the property or persons therein. But this is tough. A threshold of significant harm regarding climate change, like space, could be too late to say sorry and present irreversible damage. So sometimes it helps to define what it is by what it isn't. So what is disregard in space? And we've been talking about this kind of all day. Although other domains deal with similar sustainability considerations, the physics of space make it really difficult for long-term problems like space debris that are significantly more concerning. Orbital debris above 800 kilometers can stay in space for decades. Beyond 1,000 kilometers, it can stay in space for more than a century. Dead satellites, launch vehicles, more than 90% of objects in near Earth space are non-functional and considered space debris. We add then the use of kinetic ASATs and no definition of what even long-lived means. There's just this kind of theme of lack of definitions, but we don't even know what that is. And then interference on the non-kinetic side, jamming, dazzling, that's acting in disregard in space. You also have this kind of pressing where who is involved, where commercial and military assets are increasingly becoming more and more commingled. So it's hard to distinguish between military on military and military on commercial actions. And additionally, we have a lot of non-moverable assets in space that can be interference. Only 5% are actually maneuverable. So what then should due regard look like in space? Is it balancing the rights to freedom and minimizing potential impairment like in space? I like this quote, disregard proves disrespect, but due regard promises respect, but tempered by the reality that respect for all inevitably involves trade-offs and judgments. Is it freedom of movement for everyone? But then you pose the issue of how close is too close. And you look at RPO and you can have these dual uses where something can be help eliminate space debris, but also then a space weapon. So do you look at freedom of movement, or do you look at preservation of space for all parties? Kind of look at more like climate change. But what is preservation of space for all parties? Does every player have the same definition? And if you look at do no harm, there are tremendous economic opportunities in space, both from commercial services and space mining that offer financial incentives to harm space. So how else can we promote safety, security, and sustainability in outer space? Well, one is increased communication and engagement. And this is a huge problem where, us in this room and the space nerds out there, we know this is a problem, but most of the world does not. Bring it up in a dinner party and people think you're crazy. They don't know about this. And so just getting the word out there, and then also this idea of increasing transparency for all. And so, we've been talking about how space is vast and a lot can happen in space and we don't know. So increasing space situational awareness, getting eyes in space so that you can deter this disregard in space. And then begin with these quickly achievable demonstrations. So looking at like quick wins, how can we start with maybe what we agree with and with these smaller groups and then build on that, kind of looking at like confers and their RPO. and concentrate on safety first before moving to the more thorny security side. So, since the Cold War, we've really been focused on defining rules and norms based on a security side, and that's been very contentious. And so maybe we need to start on the safety side, and something that we can all agree upon, like debris is bad. And instead of derailing when we get to security. But yeah, it's so maybe that's a good place to start. I'm excited to answer questions now.
All right. So, General Miller, sir, the first question is for you, which is why now? Why is the U.S. now pushing for the tenets of responsible behavior in space?
I think I've listened to the comments of the panelists. I think there's going to be probably a dozen reasons why. Let me highlight 4 from you that are most important to me. And it's really the Secretary of Defense who's asked United States Space Command to do some work on what, from the tenets that were laid out in the memo that I think everybody has seen, what are those behaviors that we think are most appropriate to try to demonstrate in partnership with our allies, as well as with civil and commercial, where we can see leadership to try to get to some basic definition of what right looks like. I think the first reason, though, that's most important to me is the threat. There's been a number of activities that have occurred over the last 2 to 3 years that are particularly concerning. Some of them have been well reported on. The November ASAT event was one that was in particular not just, it was just reckless from another different perspectives. Weekly, we are doing collision avoidance concerns from that debris, frankly, on the International Space Station, for which the Russians are on. It was just reckless in a lot of ways. And it doesn't take a lot to cause a lot of problems when you're dealing with speeds like you're seeing at low Earth orbit. So I think the threat is a concern. Some of the threats that you may or may not remember just in the last recent years, General Raymond in, I think it was February of 2020, outlined a concern about another threat, an on-orbit threat the Russians had been shadowing, was assessed to be an NRO spacecraft at the time. We had seen activity prior to this before, and he had even referenced release of a projectile. These are concerning things to us. The simple fact is that the infrastructure and the Space Force architecture, the space architecture that the United States and our allies have had in place for decades, there's just not a lot of them. You may think there are. There aren't a lot of those capabilities in particular that are out there, and we treat the potential for disruption or negation of those capabilities very, very seriously. So the threat is a big concern because you all may have seen, there was a periodical that was put out by DIA a couple of years ago, Security Challenges in Space. Almost everything that they said has occurred or has expanded in scope. So don't take my word for it, take the DIA's word for it. The threat concerns me. The second is I see reliance on space increasing, not decreasing. It is more intertwined now with the daily habits of the average American or international partner, let alone the United States military. Our desire in the past for precision, for global vigilance, the ability to project power is all underscored by space capability. And we have built our national defense architecture around that capability, whether people understand it or not. And we certainly have a role, I have a role as the Director of Training and Force Development to improve space mindedness in the United States military. The reliance has only increased. So ensuring that freedom of action that I mentioned a moment ago, that you can rely on having that capability is another reason that I think it's important. I think there's been 2 other things that have occurred that really speak to it as well. One is the United States is not the only nation that has taken steps in organizational change over the last couple of years. I think you all probably saw the chief and my boss, the commander of US Space Command, were in Australia just a couple of weeks ago for the stand-up of Defense Space Command. The United Kingdom has done something similar, the Germans, the French. There have been a number of allies and partners who have taken steps. So I think they are in a position now where we can begin to have this dialogue with other professional military organizations, not the only organizations, but certainly we have the opportunity with other professional military organizations in order to do it. And then I think the most, one of the most important things that we need to consider is there is no time like the present because candidly, the national security environment is very uncertain right now. And I am increasingly concerned about the risk of miscalculation, more so than I might have been just a couple of years ago. And certainly none of the threat demonstrations, I would argue, initial deployments of capability have done anything to make me think otherwise. Now we are probably at a place where it's more important than ever that we partner together and begin to have a dialogue about what right looks like. So in my mind, those are 4 reasons that I think we need to do it now. Over.
Thank you, sir. Ms. Dickey, can you explain when we have due regard as a basis with legal and treaty-based foundations, how does that relate to these non-binding norms and efforts to promote responsible behaviors in space?
Yeah, so when it comes to kind of the relationship between treaties and laws and norms of responsible behavior, at least in the definition I use, laws can be the foundation of creating norms. Not all laws succeed in creating norms of responsible behavior if it's not followed through in behavior and in the way actors respond to behaviors that would violate a treaty or a concept. And so it's an interesting path that we've seen in recent years of not just discussions about whether amended treaties or new treaties are necessary, but how can you improve the implementation of what we already have? And oftentimes the discussion circles back to this non-binding voluntary approach. One of the reasons for that is that these more non-binding voluntary guidelines are just more flexible. In space, the technology is changing rapidly, the situation is changing rapidly, and treaties do not change rapidly. They can be extremely slow to develop, and that's not to say that other aspects of diplomacy are necessarily rapid, but having built-in flexibility and adaptability in your mechanisms for establishing that commitment can be really beneficial when you take those kinds of approaches. And so that's why we see, the discussions in the United Nations that Mr. Edmondson brought up is that there's this kind of interwoven network of all of these different kinds of approaches and mechanisms. And it's not just a binary between legally binding and non-binding. The incentives that you use to enforce or kind of support voluntary behavior do not just have to be legal. You can also have political or social incentives. You can have incentives like what was established through the International Space Station, that you get to participate in this prestigious, amazing development. At the same time, you're agreeing to certain principles of responsible behavior. So again, circling back to the Artemis Accords, it's the idea that this program and all these different countries participating in the development of that program are agreeing to a certain set of principles that, while Artemis is non-binding in and of itself, is meant to be kind of an interpretation and implementation of the original Outer Space Treaty. So it's the notion that these different approaches don't have to be in conflict with each other. They're often very complementary in how you develop a stronger, broader basis for getting everyone on board. And the issue that I see is that given the physics of space, especially when it comes to debris, the action of any one actor in space affects everyone in space. And what happens in space ultimately affects everyone on Earth because of the interrelationship that General Miller described. And so that's why it's really important to try to get the entire international community, all of these actors on board. And that's not done through a single solution. It's done through a wide range of approaches.
Thank you. Mr. Edmondson, during your opening remarks, you raised an interesting question, so I'm going to give you a chance to answer it. I know my colleague, Colonel Mountain, is going to be very interested in the discussion and the concept of due regard in outer space and Article 9 of the OST and how it applies to radio frequency interference, jamming, spoofing, blocking data links, etc. So how do you envision that relationship between due regard, Article 9, and all those types of jamming and electronic warfare type activities?
I think I posed it as a question for everybody else, not for me. I think the point here, I think, is to take it back to the sort of this idea of why we do the work at all. and that's to have this holistic view of the threats that we face against the space systems. So in the past, we'd always thought about it, I think, in the general collective, in the public collective, if you like, as being two spacecraft operating near each other, and what we should do to try and manage that as a threat, as the responsible behavior. And really the challenge I think we're working through at the moment is when you look at that continuum from, of threats to space that goes all the way from sort of, plastic missiles or missile tells, somewhere in the Russian steppe all the way across to nukes in space. I think we very quickly focus on the bits that we can see and we can understand. And perhaps we in this room don't, and we might be in a unique group because we probably have a better view of the range of threats. But if we only tackle the things we can see, we leave the gap open, we leave the door open for hostile actors to focus on those bits that they think they can get away with. And I would suggest at the moment they think they can get away with RF interference, with jamming and spoofing and so on. And the challenge for us, I think, is to say, okay, if we take the answer to this threats to space systems, let's call it that, and we think the answer is this policy approach that we have titled responsible space behaviors, how do we then link back in the questions of due regard, of acting aware of other states, of other people, of how international humanitarian law applies before conflict? Well, it doesn't. So what are the principles of IHL that you can take and you can apply to non-kinetic threats? How might it affect the infrastructure, the critical national infrastructure of another state if we were to do some sort of cyber attack or RF attack? And what were the rules we would apply to ourselves? And then back to this very fundamental principle of what is due regard. And do we have a shared understanding of, I'm doing this to you? Do you understand what I'm doing to you? Do you receive it in the way that I meant to send it? Do we have a shared language? Do we have a way you can complain to me that you don't like what I'm doing to you? I think we have those things. We have more of those things in the physical world, in this spacecraft on spacecraft world. I don't think we have any of those in the RF world. And so when you get an instance like last year, Royal Naval warship going through the Black Sea, we claimed it was in the international sea lane going from Ukraine across the bottom end of Crimea. We said it was in international waters. The Russians said, no, you're not, you're in our territorial waters. You have to have a way that you can have a conversation about that, because quite clearly an RF threat was then becoming a physical threat and threatened a warship, and therefore, you hate to think what would escalate out of that. If we make the links between space and our nuclear deterrence, whether it's early warning or it's the actual process of being able to deliver a second strike, most of the effects that would take place pre-conflict would be RF interference, probably. So do we understand how to complain about RF interference before we start to get kinetic? So no, I don't have the answers, but I'd like to challenge the people on the floor to come back with a few.
Thank you. Last question from me is from Ms. Festel, which talks about one of our great power competitors, Russia. So Russia is known for demanding very legalistic agreements to govern behaviors. And they've done it for years. They don't always implement what they demand, but that's what they generally demand. But what do you see as the issues with that approach to agreeing potentially with the Russian demands for these very legalistic regimes that they want?
Yeah, I think Mr. Edmondson kind of touched on this too in his response about when you're very explicit of what you can't do, then it opens up to find how to find a workaround. I feel like being a parent is a really good experience to like better understand deterrence. With kids, you set a line and they'll just figure out they'll just get more creative, right? To figure out how to get around. And so I feel like kind of some of that of if you're really explicit on exactly what you can't do, then it's not going to really stop the actions you're trying to deter. It's just going to come out in a different way. So I think that's not the golden answer to like how we're going to tackle that, because it's not going to, again, deter the behaviors we're looking to deter.
All right, thank you. So I have a lot of more questions, but I'm not going to ask them. I will turn it over to the audience, both in person and online, to see if they have questions for our panel.
All right, as we move microphones over to in-person questioners, let me just kick off with a virtual question. This is from Michael Listener. And Mr. Listener writes, we all want clear black letter law, but international law is anything but clear and concise. Instead of a legal definition of what constitutes or represents the absence of due regard and harmful interference / responsible behavior, a policy determination made through a legal / totality of the circumstances test. What do we think of that?
Question for you, and I'll also point out that if nobody has realized it up to this point, this is a policy panel. They're not lawyers. I'm the only lawyer that's up here on the stage right now. That's a great question because we have policy people here to answer that. So
yeah, looking at the question of definitions in general is a difficult one. Part of the issue is that a definition is not the solution to every problem. Although you can point to ambiguity or a lack of definition and say, oh, that's an issue, it's not always the solution to create something that's written down in very explicit codified language. You have to think of kind of what are the strengths and weaknesses of each possible definition, as well as what are the potential costs of setting a clear definition. Some of the costs were already mentioned in terms of if you make it too specific, you'll create a loophole of some kind. And maybe a specific example of challenging issue of definitions is what is a space weapon? That could be an absolute black hole of legal and policy discussion, especially when you think of dual use issues. And so when you're looking at that issue, the solution may not be to set a clear definition of space weapon, but instead it might be what are the behaviors related to that issue that might come to the forefront or might feel threatening or challenging to different actors. There's also the issue that I mentioned earlier of having different languages, and there's extensive process in the legal and diplomatic and policy world to try to deconflict that, but you still see it coming up as an issue all the time in negotiations. For example, many languages do not have a distinction between the words for security and safety, which is an underpinning of how the discussions are supposed to happen in the UN, is that there's certain avenues that really focus on security and disarmament issues, and there are others that focus on safety and sustainability. And so in many ways, I think the challenge is not to look at what's the wording, what's the clear definition, it's what are the linguistic, cultural, behavioral underpinnings that you're actually trying to get to when you're creating these responsible behaviors.
does anyone have thoughts on that question that they want to provide?
I like the answer, and despite the fact I'm a policy person, I've spent enough time with lawyers to be able to say it depends.
Major Toronto. Ms. Feistel touched on RPO, rendezvous proximity operations. And a question I have for not just her, but anyone here is by policy, how close is too close?
It's a great question. I am neither, well, apparently none of us are lawyers, but as the sibling of 3 lawyers, I'm smart enough to say that depends as well. I think there's a number of things it depends on. Certainly the current security context, what is the state of relationships between 2 parties factors into that calculus. Where it is, I think Mr. Edmondson talked about orbital regimes matter. What type of risk is assessed from that given threat will matter. And obviously, for us, the level of resilience that we think we can contend with, does losing one thing drive you into a place where mission failure is there? All of those things will go into a calculus. I think it is, and more, frankly. I think it would be too easy and almost too formulaic, like you've heard here, to try to say that there's one distance that will drive you in that place. There are certainly things that have put us in a place where we've tried to, from a safety perspective, communicate warnings of concern. I mentioned avoidance messages that have been sent out about the International Space Station, for example. There are a number of things that go into that calculus, not just distance, uncertainty of the error. last observations we've had from a reliable sensor on that object. How big is that object? How well tracked is it? There are a number of things that go into this calculus for us to make us, help us inform what actions we need to take. What I will say is, from a US perspective, in every one of those instances, certainly from a safety and sustainability perspective, we try to provide outreach to almost any nation or civil or commercial partner when we think there is something of concern. What we do not have, and this has been mentioned before, although there are good templates and examples in other domains, is necessarily the communication platforms and the habitual engagement with those peers in those other services, those other nations, those other communities that will allow for a frank and candid discussion about the different types of things that make us uncomfortable. There are things that will make me uncomfortable, but you literally pay me not to assume the best from people. Depending on who the opposite party is, there may be a greater level of risk they're willing to assume. But if we can't have a dialogue, we're going to be starting from a place of miscommunication. So I think it's difficult to say that there's one thing, but there are a number of things that we can begin to talk about, and this discussion of due regard and what right looks like allows us a forum to do it. I would say that all of it, and this is in the Secretary's memo, all of it is underpinned by habitual forums for us to have communication, just like we have in other domains. And we need to have it with the owners and operators of those systems, not people who don't understand what we're talking about. Does that make sense?
Just to add, okay, there we go. Just to add too, I think that speaks to the need for greater and greater space situational awareness and eyes in space, so that too, it's not just, you know, maybe the US versus blah saying, oh, you're too close, but we have this like accountability to people say, no, that's actually too close, and the transparency to know what's actually happening, so that you don't have unintended consequences or miscalculations and misunderstandings.
Thank you. Hi, Andrea Harrington. So I want to ask about the relationship between the legal tool of due regard and how we use that to achieve policy objectives. So we have this legal tool that's binding, it's built into the Outer Space Treaty, that's the due regard principle. And we have policy objectives that we are trying to meet regarding responsible space behavior or responsible behavior in space, depending on who you talk to. And so the question is, do we commit, is there will to use that legal tool that we have available to us to achieve our policy objectives? Can we link those two concepts by, for example, using those non-binding guidelines as a tool of treaty interpretation, either as a subsequent agreement or as something that's generating subsequent state practice to help with interpreting what due regard means for us under the Outer Space Treaty? Or through some other means like a totality of the circumstances test that Michael Lisner mentioned, or using a foreseeability of harm standard more in line with some other areas of international law outside of space. But is there an appetite in general to look at this tool that we have, this due regard tool, and apply it to achieve our policy objectives? Or is that the kitchen appliance that's going to stay in the drawer and we'll keep talking about, it's really useful, we just have to figure out how to use it? Thanks.
I suppose the question here is, with whom are you trying to use this kitchen appliance? Have you got a bunch of friends around that you're just going to muck about in the kitchen for the afternoon or the evening, and you're going to cook together and you're going to have a bit of a chat, and you're going to use this implement that's sitting in the kitchen drawer most of the time, but if you make a bit of a mess of it, nobody really cares? Or are you going to do it with somebody, you know, you really want to impress? Is there somebody special that you're going to be using cooking for? You know, what's the response that you want out of using the kitchen appliance? And I think there's a real danger as well that that sometimes it's with strangers and they don't know you and you don't know them, and they've no idea why you ever bought the kitchen appliance. In fact, you didn't buy the kitchen appliance, you were given the kitchen appliance by your mother-in-law. I think essentially, and trying to take this back a fraction, but very often we have conversations or we talk at people and we utilize these things and we think we understand what they mean, and they have no idea that we mean this by that. And so we've got this really interesting tool in the toolkit called due regard, and we don't know what it means. Like, we think we do, but we have actually no idea of using it with effect, which I think is your point. How do you make this thing have teeth in what is a fairly toothless world of space security and the law? Because the people you're trying to impact and influence are not your friends that came round for dinner to muck about making curry for 3 hours and too much red wine on Saturday afternoon. These are people, the people you're trying to influence are those people who'd quite like to shape your way of life. They want to change how you live your life, and they want you to do something different. And if you're going to bring this tool out of the toolkit, you've got to, you kind of get one chance to make it work the first time. And I think that's, for me personally, as a policy practitioner, is where we've been uncomfortable, is when am I actually going to take it out of the drawer and use it, because I don't quite understand the effect it's going to have, not necessarily on state actor A, who may be the state actor that's the problem for us, but state actors F, G, and H, because those are the ones we need to influence. And a big chunk of the work we do multilaterally and internationally is to affect state actor A or B, those that are close to us, or that are providing the problem for us, but also to make sure that state actors F, G, and H understand what we're saying and that they have an instinctive alignment and agreement with us. And that's why this stuff takes so long, because we could do it bilaterally or multilaterally or in a small group and agree this thing, but all those other state actors won't understand and they won't agree. And then what have you actually achieved? So when you do want to use something like due regard, yes, it exists. And we could shout it at another state actor. They might just completely ignore us. And then it just sounds like, the two of us having an argument, and everybody else in the room kind of thinks, why don't those two shut up? So I think this is, I'm not trying to avoid the question. I think it's an excellent question. And when you take it away from due regard of something physical that you can see, and then you think about due regard for something you can't see, it's very, very difficult to think about how it has policy utility without a long series of conversations and international engagements and trust building and so on. So do I think it has utility right now? Well, I'll probably get shouted at, but no, not right now. Do I think we could have some good conversations about it over the next few years? Yeah. Do we have patience? Kind of got to have.
I could chime in and build off of that a little bit, especially what you said at the end about what you can't see. I think one of the biggest challenges in translating from a legal tool like due regard into policy and practice that's pretty, unique or is central to space is the idea of space situational awareness. We've already talked about the issue that interpretive lenses, definitions, and how we interpret the behavior that we see can be very different from different actors. But then there's also the problem that we might be seeing entirely different things, or some actors might not be seeing anything. And so when you're trying to create these broad international understandings of what's going on, the idea of having access to information that you trust and can interpret and understand that demonstrates whether someone behaved in a certain manner, what actions they took in space, that's an essential, crucial first step before you can even begin to discuss what that means and what to do about it. My colleague, Mick Gleason, recently published a paper, since we at CSBS do funny names, it's called No Haven for Misbehaving. And it's the idea that when you're creating norms of behavior, if you want to get that commitment, if you want other countries to accept those constraints on their behavior, there has to be a level of trust that they can observe when bad behavior is happening and respond accordingly. And so it becomes not just a question of having a circle of trust with your close friends and allies that you can share your data with and they'll see that and trust what's going on. It's how do you get trusted data to other countries, the hundreds of countries around the world that don't necessarily have those capabilities. And so it's that twofold issue of capability and trust when it comes to space situational awareness that is just a really challenging hurdle to get over when you're trying to go from principles to practice.
Can I add one thing? So I think I agree with that. I would like to point out, and General Burt, I think, is here later today or tomorrow. So the Combined Force Space Component Commander, Major General Deanna Burt, will be here, I think, today or tomorrow. For those of you who are U.S., your government has done things, taken steps, produced a catalog, and releases it. Frankly, to some extent, it makes me uncomfortable as a military professional how much we release. But in the interest of building on a platform of we've got to provide some level of shared awareness, provide an accurate level of prediction for people, demonstrate the tools of which we're making decisions or recommendations on collision avoidance maneuvers, things like that. There are things that the government has started to do. And this discussion today, and why I say this dialogue, I think can and needs to occur. I agree with Mr. Edmondson's point about patience, particularly in the international sphere. I think that there's a, I don't know what that carpet is, but there's a limit to the length of that carpet that people are willing to walk on. For us, because you literally want us to do everything we can to avoid conflict, these are discussions that are going to happen. And it is also why U.S. Space Command is, and actually it's in statute now, we're looking to provide that capability through, because there are frankly people who will never trust anything I say just because it's the United States military providing it. Provide that platform through, in this case, the Department of Commerce is who we have in statute right now, tasked to take that over from us, because I don't think it's an inherently military function, candidly, but I do think there's opportunity here. So it's not all doom and gloom. There is precedence, there is opportunity here. And to the point I think everybody's saying here is there's no time like the present for which folks need to engage on this issue. So there is some opportunity that's in the near term. There's frankly even resourcing that's been proposed to expand that and provide it on a much more broad scale with much more rigorous tools in the future that we can put in the hands of not just primary interlocutors that you might be seeing, as Mr. Edmondson mentioned, but also other nations and other parties that aren't nation states. So there is opportunity there. I encourage you to consider all that as you go forward. There are bases for these discussions. You're not starting at zero. So I hope that makes sense.
Good afternoon. Oh, sorry, ma'am. So my question is actually for you, ma'am, Captain Ahmed Mohammed, U.S. Air Force. You mentioned small wins. From a policy perspective, what do you think could be the catalyst to get to the bigger policy changes that we're looking for?
Yeah, I think we were trying to look at it from a more like a bottoms up approach, that like starting up here with, you know, treaties or even like the TCBMs, like that's kind of big wins. And so looking at more small wins, like collective groups of people with like common goals, starting there. So kind of looking to like Confers and what they've been able to do with RPO and trying to find these guidelines, you know, starting with that and then kind of like building off that momentum and like kind of adding parties as you go and kind of like going up that way and kind of seeing that as like more of a quick win. So maybe to breaking it up into these smaller pieces, not just all of responsible space, but like focusing on a particular aspect of it to get to that kind of more like quick win. Like what can we agree on versus just stopping where we don't agree, if that makes sense.
I'm not the policy guy. I'd like to be able to have a direct conversation with other nations' military forces who do space and be able to have, we can start with defining terms if we want to just have a discussion about the taxonomy of the relationship. I'm good with starting that conversation wherever it needs to be. We are getting to a place now, as I said to you, there are a number of reasons why I think there's a sense of urgency from which we need to move. And so far, we have been fairly restricted on either side from being able to have a dialogue that frankly is normal in every other domain. My former boss was the Deputy Combined Forces Air Component Commander in CENTCOM. They have a communication channel to the Russian aviation team that's in CENTCOM. And on a habitual basis, that prevents misunderstanding, confusion, and potentially the risk of escalation. There are ways to do this, and the first step is to have a discussion or a meeting, and I'm happy to do it virtually and keep everybody COVID safe. But I think we need to start having this dialogue, and we need to recognize that there is value to establishing those habitual relationships up front, and they will never be the only place that discussion occurs. But there is something that we have to do in order to get along, and this is a first step that I think is a necessary first step, at least from a military standpoint.
Because I think what you just mentioned, I think begs a follow-up question which is about, do we have right now effective crisis communication tools with other states or even with our own private space enterprises, so that if there is a situation where, like the Chinese complained of, where we would need to reach a certain one of our private operators, that we could do that? Do we have those crisis communications in place right now?
I think what I would say is it depends on who is the opposite party. We absolutely, as I said, provide, it's largely via email now, to almost any user, unless they provide us a phone number that they'll actually pick up, an opportunity to say, hey, we are concerned about this from a safety perspective. All nations will get that we have contact information for. General Burt's team at the Combined Space Operations Center has regular, and they actually have a commercial integration cell that has the commercial partners right there. So if they have a direct line into their operations center to talk about it. We have NASA right there. We have European Space Agency relationships. Those relationships with what I'll call not your traditional allies partners are not as mature, and those are the things that I'm talking about that we need to establish. And frankly, if you look at what the Secretary recommended in his Tenets of Responsible Behavior, it's right in there. I think he is thinking similarly. I just think we need to get about the business of actually making it happen.
Good afternoon, Robert Jarman. In that last discussion from Major General Miller is a perfect segue to this question. To what extent have the panelists considered some models of military agreements that we've seen historically in the past, like the Incidents at Sea Agreement from 1972 between the US and the Soviet Union, which governed maritime encounters and air and maritime encounters. The US subsequently entered into non-binding agreements with China in the 2014-15 timeframe, governing both maritime and air-to-air encounters. Both of those are essentially mechanisms to flesh out due regard. A series of essentially irresponsible behaviors were codified in agreement. And then important to Major General Miller's point, they established mechanisms where the militaries from both sides would gather annually or biannually to work through specific incidents and discuss what conduct is professional, what conduct is irresponsible, and to build relationships, build that dialogue, build state practice, build a sense of consensus about what responsible behavior is. To what extent have you all thought about that? And Major General Miller, if that's something that you're prepared to talk to, is that something you would be open to considering going forward? Thank you.
I'll give a very brief remark while you compose your own response. We do think about that quite a lot, but I think this is where we've made a rod for our own backs on how we have thought about space. It's very easy if there are two ships going past each other, they're painted gray and they've got military numbering on them. You're pretty sure it's a warship. Looks like a warship, sounds like a warship, it's a warship. Do we do that in space? We somehow seem to want to pretend that we don't know what their stuff is, or they don't know what our stuff is, or what the capabilities are and all the rest of it, because it's a box in space. But I mean, we have a reasonably good idea of what's going on up there. So translating something like INCSE across to space is easy for flying operations, if I can call it that. I think it's much harder for a whole load of the implications of Cosmos 2519, if you like, sitting next to a high value asset. What are you going to say? If you pick the phone up, which is what actually did happen in that instance, what are you going to say? That asset that didn't in theory exist, and it's a small black box that's sitting next to it. I mean, essentially, yes, that is the point about the behaviors approach. You should be able to ring somebody up and say, I'm uncomfortable, I feel threatened, I perceive a threat, but then you have to explain why. So yeah, we've thought about it, it's just not simple.
I don't want to scoop General Miller when I talk about the example of SpaceCom, direct space situational awareness, data sharing agreements with a number of entities, both military, commercial, universities. Like those partnerships are not necessarily under the title of we are going to decide some responsible behaviors, but they can have immense, positive effects towards the building of common understanding, common practice, building those communications. So there are lots of cases in which you are building relationships and having conversations, especially sometimes helpful at a lower level that isn't, building up into the big political diplomatic hullabaloo that you can sometimes get with talking points. So it can certainly be very helpful, but there's also the flip side of the challenge is one of scope. How many bilateral direct conversations can you have feasibly in a time to build this broader conversation? And how can you take something that's specific, like a specific data sharing agreement, working together on a specific program, and really translate that to a broader principle, a broader discussion to bring people together? So it's a double-edged sword in terms of something being very practical and very efficient when it comes to the initial relationship and development. But when you're looking at trying to build broad international conceptions of responsible behavior, you can sometimes get caught at that translation point from these small efforts to the broader issue.
Just to add, I think it would be ignorant not to try to look to see what air and sea is done and just to throw that out. I think there's definitely lessons to be learned there, but space is different. And, Mrs. Talk shared this morning, satellites don't have mothers, they don't have babies. And at the end of the day, it's a very expensive box sitting up there. And so it is different. The loss of human life is very small. There's only a few people up there at a time. And so there is difference. There's difference in the physics. There's difference in the debris we generate and how long it's going to be up there. There's differences in, like we've already talked about, like even being able to see what's going on. And so, yes, we can look there for lessons, but it's different enough that we have to do this exercise independently.
The only thing I would add is, and the team is right here. We have, it's not easy. Everything that was easy, they left to the lieutenants. I don't expect anything to be easy that I'm dealing with. But I would say, I think we got someplace where we can begin to have more of a fertile discussion here. A couple things I point out. Absolutely, we do have SSA, dozens of SSA sharing arrangements. I also think there's a little bit, we talked about double-edged swords a moment ago. The space, there are different physics that govern what we do in space than what we do in the air domain. I'll concede the point. And certainly the operations and activities are different at which we do it. But sometimes space ops for people who are uninitiated mean new ops. And by virtue of that, questions start getting answered that actually undermine the level of cooperation, if it's an ally or a partner I'm talking about, or potentially undermine the ability to have a clear, candid discussion with a professional on the other end of the phone. They are not the exclusive or the only communication channel that I think could exist. Frankly, I would not recommend it because it's not necessarily compelling. But what it does offer is yet another opportunity. In some cases, the messages that we send out right now for just basic safety things just are not responded to. And it's because we don't have reliable interlocutor. And that takes a level of cooperation. But what I do like about it is if we're doing it on the safety side, if we do get to a concern about the threat side, that's not the first time we're having that conversation. And that's where I see, and I believe where we think from US Space Command perspective, there is an opportunity here. So yeah, we would encourage it. It absolutely, I'll be very clear, it is not the only place to have a discussion. And I'm not talking about having policy formulation discussions at that level. What I am trying to get in places, we know the places where command and control occurs in some of these other locations. We know the C2 centers. We even know who the leaders are. There has to be a way to have a frank and honest discussion when we have safety concerns that neither of us want to see the consequences of. And frankly, them not picking up the phone after we've had some of these discussions, that sends a message too. So I think that there is an opportunity there. I think we think in Space Command that we should try to explore that opportunity, obviously with our partners. No one's trying to do anything in secret here. our number one objective is to deter the potential for conflict, right? First and foremost is clarify the potential for miscalculation, avoid and limit escalation, clarify where we can attribute hostile action or even safety concerns, and take steps to mitigate each of those. Those are things that I think we can have a candid discussion about, particularly with professionals on the other end of the phone who've been doing this business, some of them for longer than I've been doing it. Does that make sense?
I've just got a question. It builds on some of the comments that have already been made in terms of transparency versus security. And I wonder whether, and it's going to make Major General Miller really uncomfortable, because it's about actually the classification of everything we do in relation to the space domain, not just in terms of dealing with adversaries or other parties, but also dealing with friends and allies. And I wonder whether and to what extent the panel thinks that from a policy perspective, we need to review how we look at classification of information, how we look at information sharing, or how we look at declassifying information in a very quick way in order to be able to respond quickly to emerging threats. And I would give an example of what's happening in Ukraine at the moment and the ability of intelligence that would have been held at a strap clearance level to make it all the way through the clearance process and be released into the public domain on Facebook and through the news by the military in order to counter the Russian narrative and get ahead of it. And I worry in the space domain, we are nowhere near as agile because we classify everything even more. And I wonder how uncomfortable, General Miller, do we have to make you in order that we can be really agile?
Why am I getting all the questions? I agree with everything you're saying. I don't, I think that's a whole separate discussion about the utilization of declassification as a deterrence tool, or at least an assurance tool potentially for our allies, and frankly for some other things that we do. I'm not going to get into that part. What I will say is I think that it's been well covered ground from frankly some of my bosses throughout the last several years, that I think we absolutely agree with you that overclassification is probably the wrong word. I would just say right sizing classification is a better word. There are some things that we have, and there's good value in classification, particularly when you're protecting sensitive operations, sensitive technologies, and things like that. There's some fact of things that we can have discussions about. There are in my view, that should be reviewed. There are opportunities for partnerships that we're frankly probably missing because of it in other areas. I will say, as you know, that infrastructure it takes to do that level of classification is not insignificant. And frankly, there's good reason behind that. They want people who understand what's in those security classification guides and all the tentacles that go out to other security classification guides, why and how you do that. But I think, if I'm not mistaken, I think within the OSD, there is a review going on for some of this. It's not going to be a one answer, one go type of response. I have no issue whatsoever with that review. I think there's some cases where I can point to where it's been less than helpful and frankly slowed us down. I do think that recent events could be used as a template. I think where I get to this point, there is certainly a difference in space, but there are just a lot of folks who don't understand it. And because they don't understand what we're doing, even when there's dramatic similarities from other domains, automatically it defaults to a bin of it's over there and let's just keep it over there. And I think that that's not helpful. I will say over the last, I guess since this summer I've been in this job, I've seen some incredible moves within the intelligence community to go from really sensitive US, nobody taught you, burn your eyes out, kill your mother kind of classification to releasable in a pretty quick time when we needed things to be coordinated with our partners. So I do think there's a potential there. That doesn't mean it went down to unclassified, put it in the newspaper. But I think that there are things we can do because I've seen it occur. And I think there are more people who agree with that than you might think. And I hope that the work that I understand is happening, I think it's OSD INS is doing it. to try to get after some of this will yield some results pretty soon.
Thank you so much, sir. We have a few questions that have been piling up in the Q&A box in the virtual chat. So we're going to try and double tap two of them to hopefully open this up to an array of panelists. First question from the chat that I wanted to ask is Mr. Matt Ruane from JACQ asks, can anyone comment on the apparent safety and security value of using an ISO standard development process to define the tech and practices supporting due regard? And then secondary question from Mr. Adrian Times of CubeCab, question about space debris and whether if a US commercial operator tries to clean up another country's debris, if that country has any sort of action that it can take against that company or against the US as a whole. Can it prevent a private company from cleaning up its space debris? Thank you.
I didn't hear. What was the first question you asked?
Sorry, first question, sir, was can anyone comment on the safety and security value of using an ISO standard or standards development process to define tech and practices supporting due regard?
What an interesting question. I mean, ISO is a great one body of many in which you can have the conversations to try and define the standards that you want to have in operations. And we've seen that with what was space traffic management has now become space traffic coordination and the discussions there. And probably under that, you could have something that follows on due regard and how you apply being aware of other states. On the second point on active debris removal or debris removal processes, it's one of the big things at the moment that I think we in the international community are trying to get to the bottom of is how do you take Soviet era rocket bodies out of space when they are owned by Russia? And it's not acceptable at the moment under the way that the treaties are written to touch the rocket bodies of another state, let alone the satellites of another state. But if you just think of all those genuinely dead bits of stuff floating around up there, we'd really like to take it out, but we can't. And so we do have to work on that. And as to, can you actually come back on it? I think the fact is that if it were a US company, the US would refuse to give a license to take the rocket body of another state out.
Question from the orange mic down here on the floor.
All right, thank you so much, General Miller, for calling me out. I'm also going to call myself out and say I understand absolutely nothing about space. Therefore, I rely on my good colleague, Todd Pennington, and his team for any space law questions. But I do want to ask a question about responsible behavior and this concept of norms with a little n that we talked about earlier. In looking at it from the perspective of what we do in space, which I think is a lot of the conversation we've been having here, what we do through space, which I think is sometimes where that transparency question that will make some of our military folks shiver a little bit. But then I'd also think about, several of you mentioned commingling and that entanglement that happens more in space than in perhaps any other domain, where we might be able to learn lessons from air and sea and underwater things, but perhaps cyber, which is still kind of that emerging law, that entanglement that we have between states, between actors in states, military and other national defense or other agencies, and then commercial. When you wrap all of those together, do you really need one standard of due regard, or do you end up with some that you might have a Venn diagram of what works for all, but there really ought to be some understanding that there are going to be some distinctions between those?
So one thing that really came to mind when I was developing the framework for thinking about how we develop norms, the main conclusion that I had is there is no one size fits all approach. And you really have to think about the context, the technologies, the existence or non-existence of definitions, where something falls on the safety versus sustainability versus security scale. And so that each norm that you might think of developing, each standard, each guideline, may go through an entirely different process from start to end in terms of development. in terms of status of legality, and it might develop very differently, as applied to some actors versus others, especially when you have such a range of capabilities, such a range of legal regimes and statuses that different actors are operating within. And so having to kind of select from a menu of approaches and mix and match them, I think is particularly crucial when it comes to space, because there is that level of entanglement. There is the sometimes blurred line between safety and security, and there's the blurred line between what someone's doing and how that affects someone else, either at the same time or years in the future. And so trying to deal with all of these time, technology, capability, and actor differences is such a complex task that I definitely think taking lots of different bites of the apple and figuring out what builds the best comprehensive approach is the way that might be more successful than trying to score the solution in law or policy that solves all your problems.
One thing, when I've been thinking about this too, like, should due regard be the same for everyone, or should there be kind of different rules depending on who you are? But one thing I get tripped up on is, because of this entanglement between commercial and military, if we too kind of parse it out and have different rules, would it incentivize then to military then to kind of use commercials like a Trojan horse, or to try to, like, would that just incentivize more commingling, because then you could have different rules because you're within commercial? Or I'm struggling with how you would enforce that and like keep it separate.
But for now, first I want to say, clearly I have a challenger in the space fund. Normentum, I love it, absolutely love it. And I would be operating without due regard if I did not thank our panelists and provide each of them with one of our coveted conference coins.